A federal judge in Tennessee on Wednesday ordered that Kilmar Abrego Garcia be released from criminal detention as he awaits trial on human smuggling charges, while a federal judge in Maryland ordered that the Salvadoran migrant be returned to that state and placed under the same supervision that existed before he was wrongly deported in March. U.S. District Judge Paula Sinis in Maryland barred immigration authorities from taking Abrego into custody upon his release in Tennessee, and ordered that the Trump administration give him at least 3 days' notice if it moves to deport him to a country other than El Salvador, which administration officials have said they could do. It remained unclear Wednesday when Abrego could be released from U.S. Marshals custody in Tennessee under U.S. District Judge Waverly D. Crenshaw Jr.'s order, which left that decision to a magistrate judge. That judge issued a 30-day stay on his release, pending a further order. The order from Zenas in Maryland allows Abrego's civil attorneys time to seek to keep U.S. Immigration and Customs Enforcement from again quickly deporting him without an opportunity to argue on his behalf, a concern they have voiced repeatedly since Abrego was returned from El Salvador last month to face the human smuggling charges. Wednesday's orders marked a pair of resounding defeats for the Trump administration in the legal drama surrounding Abrego, after he was deported to a notorious El Salvador prison in March, in violation of a federal immigration judge's 2019 order, barring his removal to that country. The case has exemplified the Trump administration's aggressive deportation efforts, and the recalcitrant stance it has taken with federal judges on immigration and other topics in a clash between the executive branch's claims of broad powers and judges' efforts to keep those powers within the bounds of what they consider the law and the Constitution. On Wednesday, a Department of Homeland Security spokesperson continued the administration's vociferous approach to the case, attacking Zenas' decision on social media. The fact this unhinged judge is trying to tell ICE they can't arrest an MS-13 gang member, indicted by a grand jury for human trafficking, and subject to immigration arrest under federal law is lawless and insane, Tricia McLaughlin, the DHS spokesperson, said on X. Wednesday's written opinion from the Tennessee judge, however, was dismissive of the Justice Department's attempts in court to tie Abrego to the transnational gang. Crenshaw wrote that he'd seen no evidence that Abrego has markings or tattoos showing gang affiliation, has working relationships with known MS-13 members, ever told any of the witnesses that he is an MS-13 member, or has ever been affiliated with any sort of gang activity. Based on the record before it, for the court to find that Abrego is member of or in affiliation with MS-13, Crenshaw wrote, it would have to make so many inferences from the government's proffered evidence in its favor that such conclusion would border on fanciful. Crenshaw, like a Tennessee magistrate judge before him, ruled that the government failed to show on appeal that this case is one of the carefully limited exceptions where detention pending trial is justified, entitling Abrego to his liberty in the meantime. Abrego, who entered the United States illegally around 2011 after fleeing a gang seeking to recruit him in El Salvador, has been held in a Tennessee jail since he was brought back to the United States to face the human smuggling charges that stemmed from a 2022 traffic stop near Cookeville, Tennessee. Zenas' action came after hearings this month during which she repeatedly tried to pin down Justice Department lawyers and a government witness about the administration's plans to deport Abrego again, in a scenario where he is released in Tennessee pending his criminal trial. A Justice Department lawyer told Zenas that the Trump administration planned to again deport Abrego, this time to a country other than El Salvador, without waiting for the outcome of the human smuggling charges, should a judge in that case release him pending trial. Sinis' order on Wednesday mandated that Abrego's status be restored to what it was before his detainment in March, when he was allowed to remain free and work. He checked in with immigration authorities several times in the years leading up to his deportation, according to a pretrial services report cited by Crenshaw in his ruling. Zenas said in her decision that, upon his release from criminal custody in the Middle District of Tennessee, the defendants shall not take Abrego Garcia into custody, including but not limited to custody by U.S. Immigration and Customs Enforcement, ICE. Defendants shall restore Abrego Garcia to his ICE order of supervision out of the Baltimore field office. The judge also said that any new proceedings to deport Abrego again should start in Maryland, where ICE's Baltimore field office supervised his case under the 2019 withholding of removal order. Because Abrego Garcia was under an ICE supervision order, had defendants sought to lawfully commence new immigration proceedings on March 12th, those proceedings would have begun in Baltimore, Zenas wrote. If, for example, defendants had pursued third country removal, they would have issued Abrego Garcia a notice to appear in the Baltimore field office and gone from there. The same would apply if defendants had sought to reopen his immigration case to terminate the withholding order. Immigration proceedings, in short, would have originated in ICE's Baltimore field office had Abrego García not been wrongfully removed to El Salvador. Her opinion took on the now familiar tone of a judge angered and exasperated by what she called the Trump administration's troubling history of disregarding court orders, defiance and foot-dragging, and persistent lack of transparency. Zenas said the administration's testimony and actions raised a substantial risk that Abrego García could once again be removed without due process and in a manner that would evade this court's jurisdiction and the attendant protection against further constitutional violation. Zenas tried to get answers earlier this month about how another deportation of Abrego might proceed, demanding testimony from a federal official with personal knowledge of the plans. Instead, Justice Department lawyers produced Thomas Giles, an ICE interim assistant director over enforcement and removal operations, who Zenas noted in Wednesday's opinion was ill-prepared to discuss Abrego García's immigration case and knew virtually nothing about Abrego García beyond what he had seen in the press. Abrego's lawyers tried to use Giles's testimony under cross-examination to establish that, absent some order from Zenas, the Trump administration might whisk Abrego to some country with little advance notice of where he was going or ability to contest it in court, much as the administration did in March in deporting him to El Salvador. Abrego's legal team raised concerns that he could face dangers if removed to another country, especially South Sudan, to which the administration has recently deported other migrants. Zenas's opinion Wednesday said she shared his lawyers' concerns. Defendants have done little to assure the court that absent intervention, Abrego García's due process rights will be protected, she wrote. Zenas added that her order was necessary also to prevent a repeat of Abrego García's unlawful deportation to El Salvador by way of third country removal. Defendants have taken no concrete steps to ensure that any prospective third country would not summarily return Abrego García to El Salvador in an end run around the very withholding order that offers him uncontroverted protection, Zenas wrote. Early this month, Zenas denied motions by Justice Department lawyers to dismiss the civil case brought against the Trump administration by Abrego and his family over the illegal deportation. The administration lawyers had argued that the case is now no longer relevant because her order to have him return to the United States was fulfilled when he was taken to Tennessee. But Zenas said she had not determined whether the Trump administration had fulfilled instructions from the Supreme Court that the administration ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. On Wednesday, Zenas made clear she views returning Abrego to Maryland as part of the High Court's requirements. During the 2022 traffic stop near Cookeville, State Highway Patrol troopers suspected Abrego of transporting undocumented immigrants for money. Attorney General Pam Bondi and other administration officials have accused him of being a hardened criminal and gang member, alleging in court filings that he was a prolific smuggler in a ring that illegally transported thousands of undocumented workers across the country. His lawyers and family have denied that he is involved with any gang. After a detention hearing in that case last month, U.S. Magistrate Judge Barbara D. Holmes delivered what amounted to a rebuke of the Trump administration's assertions that Abrego is a dangerous criminal by ruling he must be released pending trial. After Crenshaw affirmed that decision Wednesday, Holmes granted a request from Abrego's lawyers for a 30-day stay on any release order so they can evaluate his options. For weeks this spring, the Trump administration did not appear to be taking any steps toward returning Abrego to the United States. And Zenas showed increasing signs of frustration as officials resisted her attempts to learn more about what was being done or not done. She ordered expedited discovery because, as she said in an order in late May, of the administration's refusal to follow the orders of this court as affirmed by the U.S. Court of Appeals for the Fourth Circuit and the United States Supreme Court. Zenas has accused the administration of acting in bad faith and has kept a potential finding of contempt on the table, saying she needs to establish a record of the facts. In Wednesday's opinion, the judge noted pointedly that the administration's actions are, to be sure, the subject of a separate sanctions motion. Maria Sacchetti contributed to this report.